versus State of Arkansas petition to writ of blah, blah, blah. Yeah, here's the decision. Petition for writ of certiorari granted, writ issued, circuit court's gag order vacated. Yeah, fuck you, Barbara. Aaron Spencer has filed a petition for writ of certiorari requesting that a gag order entered in this Lonoke County Circuit Court criminal case be vacated. He argues that entry of the gag order was a plain, manifest, clear, and gross abuse of discretion, and that there is no other adequate remedy but for the writ. We agree, and we grant the petition for writ of certiorari and vacate the circuit court's gag order. Background. On November 27, 2024, Spencer was charged by felony information with second-degree murder, along with a firearm enhancement under Arkansas Code annotated section blah 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 for the shooting death of 67-year-old Michael Fosler. The state alleged that on October 8, Spencer knowingly caused Fosler's death under circumstances manifesting extreme indifference to the value of human life, a Class A felony under Arkansas Code, and blah blah blah. The circumstances of the shooting were as follows. In July 2024, Fosler has been charged with numerous SA offenses against Spencer's teenage daughter, and he was released on bond. On the night of the shooting, Spencer awoke to his dog barking and realized that his daughter was gone. Spencer found a hoodie on a stuffed animal placed in her bed. As a result, he left in his truck to search for her. Now, they don't put in here that Aaron's wife called 911 as he went out looking for his daughter. As a result, he left in his truck to search for her. Spencer located Fosler's truck with his daughter inside and is forced Fosler's truck off the highway. After an altercation, Spencer called 911 to report that he had shot Fosler. Fosler died at the scene. On December 4th, the state filed a motion for gag order, alleging that Spencer's arrest had garnered media coverage throughout the state and the nation. Attached to the motion was a press release from Spencer's attorneys, Erin Casinelli and Michael Kaiser, criticizing the decision to charge Spencer criminally as, quote, targeting a heroic father. The state also pointed to a television interview in which defense counsel allegedly stated that they felt confident that the community would side with Spencer, quote, because every one of them would have done the same thing for their child or their neighbor's child or member of their family. The state argued that a gag order was necessary to preserve the integrity of the jury pool and to ensure the right of a fair trial for both the state and the defendant. The state proposed 8 content-based limitations on the speech of any party, any attorney, or agency connected with this case, directly or indirectly. Any judicial employee or officer of the court, any public official now holding office, including but not limited to law enforcement officials, their agents, deputies, or employees, and any person subpoenaed to testify in the trial of the case. On December 9th, Spencer filed a detailed response in opposition to the motion for gag order. He ordered that granting the motion for gag order would violate his due process rights to a fair and public trial pursuant to 6th and 14th Amendments, as well as his First Amendment's right to speak pursuant to both Arkansas and the United States constitutions. Spencer requested a hearing on the state's motion to be held in open court. On December 10th, without holding a hearing, the circuit court entered the order at issue, noting the, quote, apparent public interest in this case and the resulting extensive news media coverage. The court granted the state's motion with some modifications. As grounds for the entry of the order, the court stated, quote, it appears to the court that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial. The court further noted it was, quote, seeking a fair balance between the constitutional guarantees of a free press. The order implemented the 8th prohibition requested by the state. And the order included several notations handwritten and initialized by the judge, including the addition of Spencer's family. Now, we already went through this. The order goes on to require 1. That a copy of the order be attached to any subpoena served on any witness in this matter, and 2. Redaction of any information violating the gag order from any paperwork related to the case that might be disseminated to the public. The order further states that it will, quote, be in force until this case has been disposed of or until this court orders otherwise. This order will help ensure all parties get a fair trial. Finally, the order provides that, quote, the entire case is now sealed. Thus, the Circuit Court adopted the requested prohibition contained in the state's motion for gag order with the qualifications listed in the provisions 1 to C and the sua sponte sealing of the entire case. On February 2nd, 2025, Spencer filed in this court a petition for writ of certiorari and for other relief. The state filed a response on February 12th, and Spencer later filed a motion to stay proceedings in the Circuit Court, take the petition as a case, and set a briefing schedule pursuant to Arkansas Supreme Court rule. Here's another footnote. We note that this order is nearly identical to the orders we vacated without written opinion in Arkansas Democrat Gazette, Inc. versus State of Arkansas. Petition for writ of certiorari granted. Although the present order does not expressly apply to media outlets, the 8 prohibition on speech and the 7 provisions for information not prohibited by the order use the same language as in the Arkansas Democrat Gazette gag orders, styled orders regarding publicity. Arkansas court shall no longer use this apparent form order. What was wrong with it? I don't know. Sometimes YouTube has its own thing going on. So I don't know what it is. Let's see here. Nick, is it documented what bond Spencer was released upon? No, I don't think so. At least, if somebody finds it, please send it to me. But it was a $50,000 bond, 10% cash, so $5,000, and his restrictions were to not contact the family, the Spencer family. To my knowledge, he didn't have an ankle bracelet even. Virginia says $150K. So why was he released on $5,000? To my knowledge, he only paid $5,000 bond. Huh. That's weird. But Virginia usually has the correct information. Let's continue. Spencer also requested oral argument. We granted Spencer's motion to stay proceedings in the Circuit Court, took the petition for writ of certiorari as a case, set a briefing schedule, and granted Spencer's request for oral argument. The petition is now ripe for decision. A writ of certiorari is extraordinary relief. 2 requirements must be satisfied in order for this court to grant a writ of certiorari. First, a writ of certiorari lies only when 1. It is apparent on the face of the record that there has been a plain, manifest, clear, and gross abuse of discretion, or 2. There is lack of jurisdiction, an act of excess of jurisdiction on the face of the record, or the proceeding are erroneous on the face of the record. I.d. Second, there can be no other adequate remedy but for the writ of certiorari. This court has held that a writ of certiorari is appropriate remedy when a prior restraint of speech is a plain, manifest, clear, and gross abuse of discretion. Analysis. Yeah, Fosler was 5,000. Spencer was 150,000. Yeah. Fosler had to pay $5,000. I believe his bond was 50,000, which he posted, then stayed hidden for 3 months while he signed over the house and his assets to his daughter, and then acted on the only witness in the case against him. Thank you, Crazy Cat Lady. Analysis. Spencer argues that the gag order violates the First Amendment because it is an unjustified prior restriction on certain content-based categories of speech. He further argues that the Circuit Court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. The state responds that the Circuit Court's order was within constitutional limits, protects the integrity of this case, and ensures a fair trial of both Spencer and the states. For the reasons that follow, we hold that the Circuit Court's action in entering the challenged gag order was on its face a plain, manifest, clear, and gross abuse of discretion and in excess of its authority. Further, there is no other adequate remedy except for a writ of certiorari. Standing. As an initial matter, we must address the state's argument in its response brief that Spencer lacks standing to challenge the order based on constitutional rights of others. Indeed, as a general matter, constitutional rights are personal rights and may not be raised by a third party. However, the issues raised in this petition for extraordinary writ require us to consider restriction not directed towards Spencer personally, and we decline to uphold any part of the order in light of the order's clear lack of an evidentiary basis as a whole. Here, the Circuit Court's order is extremely broad as to the persons restrained from speaking. It restrains the parties, their attorneys, any public official now holding office, along with the staff, witnesses, court staff, and the defendant's family. The order is also extremely restrictive as to what information is being shielded from public view. It restricts filing and perhaps courtroom proceedings from public view. The order implicates Spencer's right to a public trial as well as the public's right to know how its officials are conducting these criminal proceedings. The state points out that Spencer raises arguments regarding the gag order's application to the public officials and to his family, the restriction on public and press access to the court file, and the due process rights of non-parties as to entry of the order without notice. However, Spencer clearly has standing to bring this petition requesting that this court vacate the gag order in his criminal case, and we will address Spencer's arguments to the extent necessary to resolve the issues raised in the petition. And I have somebody who I need to remove. Do not follow any links posted by these fucking chatbots. Oh, I hope you take a long walk on a short pier. Jesus Christ, I hate this. Do I have to do that? I mean, I've done it extensively on my Rumble account. It seems like Twitch is not moderating according to their own rules. Oh, I hate that. If there's one thing I wish these streaming platforms do, is to vigorously find these motherfuckers who create these bot accounts and sue them into oblivion. I'm almost at the point where So I endorse using VPNs. I really do. But when these chatbots, there is clearly some companies out there that deserves to go to hell immediately, that lives on creating chatbots, spam bots, more correctly. I would not shed a tear if these people creating spam bots, buying chatbots, was removed from the human gene pool in any way, shape, or form. I hate it. I hate them with a passion. I cannot express with enough words how indifferent I would be if I saw them drowning. Every life has value. Doesn't mean I have to save them. They can bring it up on Judgment Day. Sorry for the rant. Let's continue with the important stuff. Why the fuck can't I remove that fucking comment? All right. Now let's continue. B. Freedom of speech. The First Amendment to the United States Constitution provides in part, Congress shall make no law abridging the freedom of speech. The First Amendment is made applicable to the states by the 14th Amendment. Similarly, Article 2, Section 6 of the Arkansas Constitution provides the free communication of thoughts and opinions is one of the inviolable rights of man, and all persons may freely write and publish their sentiments on all subjects. Spencer relies on both the United States Constitution and the Arkansas Constitution in arguing that the gag order in this case violates his and others' free speech rights. However, free speech rights are not absolute, and in rare cases must yield to the Sixth Amendment's guarantee of a fair trial by an impartial jury. Nebraska Press, blah, 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 discussing the Sixth Amendment. A gag order is defined as a, quote, judge's order directing parties, attorneys, witnesses, or journalists from refrain from publicly discussing the facts of a case, end quote. Black's Law Dictionary. Thus, a gag order is, by definition, a prior restraint on speech. As such, a prior restraint on speech bears a heavy presumption against its constitutional validity. In fact, the Supreme Court has recognized that criticism of the states lie at the very center of the First Amendment. This could include speech critical of judges, prosecutors, public defenders, and law enforcement. Gentile versus State Bar of Nevada. It would be difficult to single out any aspect of government or higher concern and importance to the people than the manner in which criminal trials are conducted. Quoting Richmond Newspapers Inc. versus Virginia, 1980. The Supreme Court of the United States has only directly addressed the constitutionality of gag orders as they apply to the press, not as to attorneys, parties, witnesses, or the public. Nor has the Supreme Court articulated a legal standard for when, if at all, such prior restraints would be permissible. In Nebraska Press, the court considered gag orders on the press and strongly disapproved of such prior restraints except in extraordinary circumstances. The court noted that pre-trial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically and in every kind of criminal case to an unfair trial. The court stated that it was required to determine whether the gravity of the evil discounted by its improbability justifies such invasions of free speech as is necessary to avoid the danger. To do so, the court examined the evidence before the trial judge when the order was entered to determine the nature of and extent of pre-trial news coverage, whether other measures would be likely to mitigate the effects of unrestrained pre-trial publicity, how effectively a restraining order would operate to prevent the threatened danger, and whether the precise terms of the restraining order were too broad or too vague. In Gentile versus State Bar of Nevada, the court considered the circumstances under which attorneys may be punished after speaking. The court upheld a prohibition on speech that presents a, quote, substantial likelihood of materially prejudicing an adjudicatory proceeding. Jesus Christ. English is not my first language. It's not even my second language. It's third or fourth language. My apologies for not pronouncing everything as it should. As provided for in Nevada's professional conduct rules, Gentile 501. Importantly, the Supreme Court held that the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press in Nebraska Press. Nebraska Press and Gentile provide guidance but do not answer the question whether or when gag orders may be placed on attorneys, parties, witnesses, or the public in pending cases. Here, the gag order was intended to address, quote, the need to protect the integrity of the jury pool, to ensure that, quote, all parties get a fair trial, end quote, in light of pre-trial publicity. When considering pre-trial publicity, a trial court has the difficult job of balancing constitutional interest while upholding its affirmative duty to protect the integrity of the criminal justice process. The Supreme Court made that clear in Shepard versus Maxwell, when it granted habeas relief to a petitioner who had been deprived a fair trial in a state murder conviction because of the trial judge's failure to protect him from, quote, massive, pervasive, and prejudicial publicity from the carnival atmosphere at the trial itself. The Shepard Court noted that the trial court might well have prescribed extrajudicial statements by any lawyer, party, witness, or court official which divulged prejudicial matters. We recognize that Shepard was an extreme case in which there was no doubt that the deluge of publicity reached at least some of the jury. The court ultimately concluded that Shepard had not received a fair trial consistent with the due process clause of the 14th Amendment and reversed his conviction. While intense publicity can prejudice a trial, we note that an impartial jury need not be wholly unaware of information, including potentially prejudicial information outside of the record. We now turn to the arguments regarding which standard should apply to a prior restraint on speech in the context of this case. To justify a prior restraint on free speech, there must first be a factual showing of necessity. In other words, this court must determine whether the circuit court's order is justified by a sufficient risk of material prejudice to an ongoing judicial proceeding. This court has explained, the question becomes whether the justifications for restraining order are sufficient way to eclipse the substantial weight of the interest protected by the First Amendment, which dictate the heavy presumption against the constitutional validity of prior restraints. What then is the necessary showing? Spencer argues that a gag order is permissible only under the highest level of scrutiny, that is, if there is a serious and imminent threat to the administration of criminal justice. In contrast, the state relies on Gentile and argues in favor for a heightened standard that is less rigorous than strict scrutiny. In the absence of Supreme Court precedent, the federal circuits and the states have taken different approaches to gag orders. Some courts have adopted the clear and present danger or serious and imminent threat standard. See United States versus Ford, 1987, requiring a serious and imminent threat to restrain the speech of a criminal defendant. Levine versus United States District Court, requiring either a clear and present danger or a serious or imminent threat for a prior restraint on attorney speech. Another case, and the United States v. Trump, we hold that some aspects of the defendant's speech pose a significant and imminent risk to the fair and orderly adjudication of this criminal proceeding, which justified protective action by the district court. Briner versus Takao, and more. Jesus Christ. When determining which standard to apply, we must initially recognize whose speech is being restricted. We can identify 3 categories of persons potentially subject to gag orders: attorneys of record, non-attorney trial participants, such as criminal defendants, witnesses, and court staff, and the public at large, i.e., those who are not participating in a trial. Because the gag order ended here included members of all 3 categories, we review each to establish the appropriate standards. First, we address attorney speech. The Supreme Court has recognized that speech by an attorney is subject to greater regulation than speech by others. See Gentile. The court recognized that states have historically regulated admission to the bar and exercised authority to discipline attorneys. Attorneys have access to non-public information and are viewed as authoritative, both of which pose a greater potential risk to the fairness of a trial, and attorneys are officers of the court. For the same reasons, we find it appropriate to allow greater regulation of attorney speech in context of a criminal trial than would be permissible for the speech of non-attorney trial participant or members of the public. Thus, we hold that attorneys in Arkansas may be restrained from extrajudicial speech that poses a substantial likelihood of material prejudice to an ongoing criminal proceeding. This is consistent with attorneys' existing obligation under Rule 3.6 of the Arkansas Rules of Professional Conduct regarding trial publicity. Next, we consider the free speech of non-attorney trial participants. These persons are not subject to the same rules and restrictions as attorneys, but as participants in a trial, their speech has the potential to have greater impact than the speech of non-trial participants. See Shepard. Neither prosecutors, counsel for the defense, the accused, witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. And here is the footnote. We do not address gag order on the press in this opinion because the order before us does not impose restriction on the press. Thus, we conclude that free speech protections for non-attorney trial participants are greater than those of attorneys of record, but less of those of the public at large. Therefore, we hold that the speech of non-attorney trial participant may be restrained only to the extent that it poses a serious and imminent threat of material prejudice to an ongoing criminal proceeding. Finally, we address prior restraints on the public, whose speech is afforded the most protection in the context of gag orders. Restraining the speech of the public raises obvious issues regarding lack of due process. We cannot fathom why the circuit court believed it could prohibit the speech of any public official now holding office. In fact, it is difficult to foresee any circumstance in which a prior restraint on the speech of a member of the public, which would include a public official, could be constitutional. This here is the Arkansas Supreme Court saying to Judge Barbara Factwat that, how did this even enter your mind? Are you stupid? That is my interpretation, at least. Having established the legal standards to be applied, we turn to the additional findings a circuit court must make in every case to justify the entry of a gag order restricting the speech of any individual. First, the circuit court must determine whether alternative measures would protect the parties to a right to a fair trial. Here, Spencer suggests the extensive voir dire of prospective jurors using an expanded jury pool, giving cautionary instructions, changing venue, or postponing the trial are alternatives that should be considered before restraining speech. But the circuit court heard no evidence and made no findings in this regard. In addition, the circuit court must find that a gag order would be likely to accomplish the goal of preventing prejudice to the proceedings. Again, there was no such finding in this case. Finally, a gag order must be narrowly tailored to prohibit only what is necessary to protect the integrity of the ongoing judicial proceedings. In other words, the restrictions imposed must not be overly broad. Here, many of the prohibitions of speech listed in the gag order were overly broad. For example, prohibiting the public expression of an opinion as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendants by any public official is clearly overbroad. In sum, before entering a gag order, a circuit court must specifically find, based on evidence in the record, that 1. The prospectively limited speech would pose a sufficient threat of material prejudice to an ongoing criminal proceeding, depending on whether the limitation applies to attorneys of record, non-attorney trial participants, or members of the public. 2. After consideration of alternative, less restrictive measures, none would sufficiently protect the parties' right to a fair trial. 3. The prohibitions would be likely to prevent material prejudice to the proceedings. And 4. The prohibitions are narrowly tailored to prohibit only what is necessary to prevent material prejudice to the ongoing proceedings. This here, folks, 1, 2, 3, 4, is with this decision, it's case law. It's statute. This is something that they have done it before, but this Judge Barbara shitface didn't care. So now they are making you have to do these 4 things. The language here is must, not it's your discretion if you want to. It is you have to. Not doing this is reversible error. That is what Arkansas Supreme Court says here. I think they are getting sick and tired of judges who goes outside of the law. C. Due process, vagueness, and overbreadth. Spencer also argues that the order is impermissibly vague and that it is impossible to know what is covered by some of its provisions. He stated that it is unclear, for example, whether statements on social media are restricted or must be removed, whether previously public filings now removed from public access may be shared, what, quote, for public dissemination means, and precisely who this gag order restrains. Spencer also argues that it's unclear exactly what exactly prohibition number 8 seeks to restrict. According to that provision, the named individuals cannot, quote, make any statements for public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with any attorney of record or any agent thereof. The state, of course, maintains that the gag order is not unconstitutionally vague. The void for vagueness doctrine addresses at least 2 connected but discrete due process concerns. Regulated parties should know what is required of them, so they may act accordingly. And precision and guidance are necessary so that those enforcing the law do not act in an arbitrary or discriminatory way. Stated differently, the prohibition against vague regulation of speech is based in part on the need to eliminate the impermissible risk of discriminatory enforcement. Vague prohibitions also create a chilling effect on speech because one does not know precisely what speech is prohibited. Here, we agree that the gag order is unconstitutionally vague and must be vacated. For example, who is included as part of Spencer's family? Does the order purport to restrain the speech of his second cousin and only that of his parents, spouse, or children? Due process requires more specificity. In his petition for writ of certiorari, Spencer does not develop his due process argument regarding overbreadth, but in briefing, he clarifies his assertion that the circuit court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. It is unnecessary to address overbreadth as a due process violation in this case. Our decision is governed by the free speech and void for vagueness analysis above. D. Sealing the case. Finally, we address the Circuit Court's decision to seal the case. Spencer contends that the community has a right to know what its government does in public court proceedings. He cites Arkansas Code annotated section 1610-105, which provides the sittings of every court shall be public, and every person may freely attend the sittings of every court. Here, after the court's order was entered, the case filings were removed from public view. The inherent authority to seal parts of court files is tempered by the requirements that a request to seal part of a file must be particularized, that there must be some good cause for sealing part of a file, such as a trade secret, and that it should be in effect for only so long as is necessary to protect the specified interest. Not only are the written records inaccessible to the public, but also the briefs and statements from counsel at oral argument indicate that the Lonoke County Circuit Court's courtroom was at least partially closed to the public during Spencer's arraignment. Although it appears the Circuit Court intends to close further proceedings to the public, we caution the court from doing so without an evidentiary basis and adhere to the required constitutional analysis set out in Waller versus Georgia. Mitchell v. State, Schnarr v. State. The right to a public trial is one of the most important safeguards in the prosecution of persons accused of a crime. Conclusion. The Circuit Court's gag order is far too broad and too restricted of speech protected by the First Amendment and Article 2, Section 6 of the Arkansas Constitution. It is also impermissibly vague. Further, the order was entered without the requisite findings discussed above and wholly without a factual basis. Therefore, we hold that the Circuit Court's order constitutes a plain, manifest, clear, and gross abuse of discretion for which there is no other adequate remedy. Accordingly, we issue a writ certiorari and vacate the order. By this ruling, we do not foreclose the possibility that, after an evidentiary hearing, the Circuit Court may issue a subsequent gag order narrowly tailored to specific factual findings supported by the record. However, we emphasize that a gag order, quote, should be a last resort, not a first impulse. Petition for writ of certiorari granted, writ issued, Circuit Court's gag order vacated. Wood, Womack, Highland, and Bronny concur. Rhonda K. Wood, Justice concurring. Aaron Spencer argues that the judicial gag order violates both the United States Constitution and the Arkansas Constitution. He is correct that it violates the Arkansas Constitution. I write separately because, as a matter of the state primacy doctrine, I believe we should resolve this case under the Arkansas Constitution before resorting to application of the U.S. Constitution. The test adopted by the majority is appropriate to apply under the Arkansas Constitution as explained below. There are strong reasons to stick to state constitutional law in cases like this one. First, our role as stewards of the Arkansas Constitution is best honored by examining and interpreting it instead of the U.S. Constitution. There is underdevelopment of many state constitutional issues, and we do Arkansas a disservice by avoiding the Arkansas Constitution to focus on the federal one. When the state cede to the federal, it creates the possibility of states being a mere row of shadows. In fact, we encourage litigants to raise Arkansas constitutional arguments, and we should respond accordingly and address those raised arguments when appropriate. This is especially true in an area of law where the United States Supreme Court has yet to set a clear standard. We are addressing gag orders issued in Arkansas court, and our test should not be subject to the uncertainty of federal law when we can base it on state law grounds. Why not settle it for Arkansas now and interpret our Constitution as giving additional free speech protection to our citizens? I fully join the majority's test because it's supported under an originalist interpretation of the Arkansas Constitution. And then she goes on and on. So basically what this Supreme Court judge is saying, let's stick to what we have in and then concurring. So this is a unanimous decision to tell Judge Barbara Twatface, do better. Barbara Elmore, do better. Now, sadly, they did not vacate this judge, mainly because I they haven't asked for it. The defense. I don't think so, at least. Let's see here. If they have. Let's see here. No, it doesn't look like they have asked the judge to remove herself from this case. So that's moot at the moment. I assume depending what will go on in the hearing in December, and then when the trial starts in January. Now, there are many news articles out there. There are other content creators that cover this case. I urge you to find them, watch their stuff, give a thumbs up and a comment, because the more people who cover this, the more people who get views, it will eventually, well, the chance at least of this case breaking through the glass ceiling, having it go at least somewhat viral, all it takes is a few viral posts from some content creators. Because when it does, the large accounts will follow. That is a universal truth. When we small content creators get something viral, the big ones will cover it. Now, hopefully, I will become one of these huge content creators. Now, at just under 20,000 subscribers, I'm still a small potato. Especially now, since the YouTube algorithm seems to have abandoned me. But over at Rumble, Animal Rampere says my second language is sarcasm and his third is swear words. Oh, that was so funny. Oh, let me put. I will do like this. Oh, eh. Virginia, if I remember correctly, a couple content creators were shadow banned. Yeah. This case does not bring the views it should. Even at, I believe Bob over at Defense Diaries, they cover this case. And for them as well, compared to other things they publish, maximum a third of the views. It should be so much bigger. It should be this should be the case everybody talks about, but they don't. Melanie Lilly is always demonetized for mentioning Aaron's name. Yeah, That, I mean, also when she does this, she has a fraction of the views she normally has. And it's the only way to overcome that is you guys at Rumble, now Twitch, YouTube. Talk about it on X. Sooner or later, we will break through the glass ceiling. Now, the next court hearing in this is December 16th. But if any news show up, for instance, with Aaron Spencer's run for sheriff, I will cover that as well. There are more things in the docket. I mean, we have a motion in limine. This is, for this kind of big case, there are extremely low amount of entries in this docket. Extremely. It should be more, and I don't know why. All right, folks. That is what I had for you today. And I chose this over reading the Delphi case today. I will find time for the Delphi case because we are entering the moment where the Franks motion is being heard by Judge Gull on August 1st of 2024. And I need to build myself up for that. Because that, her actions, is probably the worst I have ever seen by any judge in any case I have followed here that I've read about. Her conduct is simply evil. But you will know when I go into it. I will publicly announce it. But folks, thank you for being here. You know what to do. Help all of us through the glass ceiling about the Aaron Spencer case. And thank you. Thank you for being here. Thank you for allowing me to do this. Hit the like button, hit the subscribe button. Check if you're still subscribed, by the way. Sometimes YouTube removes subscribers. And I lost, since beginning of September, I am down about 200. So check, please. All right. From me and Mr. Jingles, who just screw off. I will see you in the next stream or video. Have a good one. See ya.